Yeah. Well, Justice Scalia was discussing the Ninth Amendment. It's like that is more of a constructual and like basically allowing people to see things that are imbued in other amendments, like the Fourth, Fifth, and Sixth Amendment, or the First and Second Amendment.
Right.
It's not really doesn't in his reading of it. It didn't create a substantive right in and of itself. Then you have the more progressive movement on that, where that again, Scalia being a very strict constitutional, you know, interpretive, he stuck very close to what the Constitution says. If it didn't say it specifically, then it didn't apply. Then you have some of the more progressive movements, and what the court really, the last time there was really ever used or discussed was during Roe versus Wade, when the Supreme Court discussed the issue of the right to an abortion, the right to life, the right, and what it was created is the right to privacy, where they said that there's no specific enumerated right to privacy in the Constitution, but essentially tied it, saying since it's not something that was specifically reserved to the government, we're going to create this right to privacy. Now,
Right.
when it was overturned, that's where they said, well, yeah, look, that basically this right to privacy was created at whole cloth, where there's no discussion of right to privacy enumerated in the Bill of Rights or in any of the other amendments. So really, there's no such thing as a right to privacy. So that's where really the dichotomy of the Ninth Amendment comes into play.
Right. The Ninth Amendment, we're trying to be as clear as we can about it, because there's actually, even though there's not a lot of case law about it, there's been a lot of scholarly debate in law review articles and different things of the sort. When you really distill it, the Ninth Amendment, and I wrote this down during my research just to refresh my memory about it, and this was the easiest way to remember. The rights not specifically enumerated are still protected. Period.
Right.
So whether you want to be expansive about rights or not, but just because it's not specifically stated in the Constitution, if there is a legitimate right, it's still protected.
Right. Right. And so, and that was the founders sort of catch all. Like,
Right.
we didn't think of it here. We're throwing this, phone a friend out there. We're going to toss this out there just to cover it. So in case this comes up at some time in the future, that it'll be out there. And it makes it clear. This is not an exhaustive Bill of Rights, because if we made it exhaustive, it could be, like some of the legislation that we see here. You got to pass it before you can know what's in it, type of stuff. Yeah, I know. I threw that in there. Like 1,000 pages of legal jargon, which says nothing. So they wanted to say, look, these are the ones we feel that are most important, but unless it's something that we specifically say you don't have, then you have that right.
Right. So another example of how these founding fathers of ours were forward thinking and wanted to create a document that wasn't simply something that was carved in stone and that's it. It can be breathed life into based upon different changes of time. It could be amended. Of course, it's a very strict way of having to make it amended. It's not just so easy to do, but it could be.